Hi, good afternoon, everyone. This is attorney Alina Nuñez, and we're going to get ready to start our live webinar today. Thank you for joining us. I'll just give you a couple of minutes for those last Miami Cuban time people to join us, but I want to respect your time and the time that we have here today and make sure that you guys get the most out of it and you're able to ask questions at the end. We'll do a Q&A. So we'll get started, let's say in about 30 seconds. And I just want to kind of go over some housekeeping things. We are live. So if you have any questions, please feel free, post them in the chat, and I will address them towards the end of the webinar, so that way it doesn't interrupt the flow and the material that we're covering. But please put them in the chat so that way we can go back and address any questions that you have. You have me here for the next 45 minutes or so of the presentation. And take advantage and ask me any questions that you'd like. And with that, we are going to go ahead and start our presentation. So you have registered for the "If you die tomorrow, will they know what to do?" I know that's a question that oftentimes we don't want to talk about, we don't want to hear. It's like, oh my God, I don't know. But that's why you're here, because we are going to address the things that you should do now and be proactive to not leave those headaches to your family members the day you're not here. So for those of you that maybe don't know me, this is the first webinar that you're attending with us. Possibly you saw about it in a day in Miami on their podcast. My name is Alina Nuñez, and I am an attorney here in Miami, and I specialize in real estate law, estate planning, and probate. I like to call myself a death and dirt lawyer. And all of these things tie in together. And a lot of times people are like, well, real estate and estate planning and probate, they're so different. Not really. Our biggest asset that we're protecting for future generations, for our children, our grandchildren, that generational legacy is real estate for the most part. Monies and other assets as well, but real estate makes up a big portion of it. So that's why I have made it my practice to inform people of what they need to do, avoid issues, debunk some myths. We're going to also cover those at the end of today's presentation and give a little bit of clarity and information on this topic that I know is something not everybody's comfortable talking about. So I am a seasoned attorney here with over 20 years of experience. I know I don't look it, but yes. I am a local girl from Miami. I went to FIU, got my bachelor's in business administration, and I got my law degree over in Nova Southeastern in Broward. I've had my own practice for about a little over 12 years that I opened up my firm. And one of the reasons why I specialize in estate planning and probate is I really do have a passion for helping people in very difficult times, losing a loved one, dealing with a loved one possibly going through dementia, Alzheimer's, and planning for that. I lost my father to Alzheimer's. I know what it's like to go down that road. Luckily, we planned and avoided all sorts of potential headaches that could have awaited from my mom or for us. And I lost my mother to cancer about 2 years ago. And because, again, we planned, avoided having to go through probate or any of those legal court process. So that is my passion. That is my why and what drives me to help educate everyone out there and avoid all the headaches that I see day in and day out in my practice. So just to give you a little bit of, I guess, background, and we're going to go through some of the key terms that we use in estate planning and in probate. Some you might have heard, some you're possibly familiar with, others you probably have no idea what they are. So some of the tools that we use in estate planning is, wills. We talk about dying intestate or intestacy, beneficiary designation, and trusts. Okay, so what exactly is estate planning? You've heard of it. You kind of have an idea. Is it just a will? It's so much more than that. So estate planning is basically the strategic organization of your assets to ensure that they're managed and distributed effectively during unexpected events such as illness, incapacity, or death. Now, assets, a lot of times people have the misconception of, well, I have to be rich to have a trust, or, well, I don't have any assets. I just have my house and a bank account. Those are your assets. Assets can include anything that you personally own, from the clothes that you wear, the jewelry that you have, to the car you drive, the home, money in your bank account. So cars, real estate, bank accounts, furniture is considered assets. Life insurance policies, investment accounts, 401k, IRAs, money market, CDs, anything like that is asset. Your personal possessions, such as artwork, jewelry. The running joke in our office and in my family is the lladros, because my mother had many lladros. And if you know what those are, according to her, they're worth a lot of money. Those are all personal assets and make up your estate. So, do I need an estate plan? This is one of the top questions I possibly get is, why do I need to do estate planning? Again, I'm not rich. I'm not a Rockefeller or Kennedy or anything like that. Well, with an estate plan, you ensure it's giving you control to say who you want to receive your inheritance, who you want to receive what, and not only that, but while you're alive, if you can't make decisions for yourself, who you nominate and pick to make those decisions for you. So estate planning is about giving you the control to be able to say who you want to make those decisions and receive your assets, instead of leaving that decision in the hands of a judge or a court who has no idea who you are. So here are some of the essential documents we're going to be touching upon today when we talk about estate planning. We have a durable power of attorney, a healthcare designation, a living will, which is different than a last will and testament. Then we also have our last will and testament and revocable living trust. These are just some of the key. There are many other variations or other things that we could use for estate planning, but these are what we call your basic estate planning documents. So we'll start with the durable power of attorney. What exactly is that? Maybe you've been familiar, you've heard of it, but not really quite sure what it is. Well, a durable power of attorney, or a POA, as we say for short, it is you signing a legal document granting someone else, the person you name, that you're designated, giving them the authority and the legal power to make decisions on your behalf, act on your behalf while you are alive, in case that you cannot. So it's either if you're in a situation where you become incapacitated, physically, mentally, you cannot, you with that power of attorney, if you did it beforehand, left everything planned, and let's say 5 years down the road, 10 years down the road, now all of a sudden you're suffering from dementia, starting to show signs of dementia, Alzheimer's, the person that you named in those documents will be able to make certain decisions on your behalf when you cannot. This becomes critical, especially in a situation where you're caring for a parent or a loved one, a spouse, and they do end up having dementia or Alzheimer's, and you need to make certain decisions. You need to sell a home to be able to put them into either like a nursing home or an ALF where they'll be able to care for them. If you do not have that power of attorney, the person that now no longer has mental capacity cannot legally sign any documents. So now you're exposing yourself to have to open a guardianship case with the court so that the court can legally appoint someone on your behalf. That's why I say estate planning is all about giving you the power of saying who you want to make those decisions. Because maybe let's say you have 3 or 4 children, and maybe you don't have the best relationship with one of your children, and that is the one that's stepping forward and saying, well, I want to be my parents' power of attorney and make decisions. And if you had your capacity, you'd be like, oh no, this is not the person that I want. That's why planning ahead of time is so important. Oftentimes, it also can be that maybe you're physically not here. Let's say you're out of the country and you're going to be out of the country for a significant amount of time. I gave a webinar several months ago on this exact issue, dealing with the immigration deportation that we're seeing nowadays. If, let's say, you own a house here, foreigners can own properties here in Florida and Miami, and all of a sudden, or even heaven forbid, worse, you have a child that's here, but you are illegal, your child has legal status, and they deport you, you need to have a durable power of attorney in place or a document in place to say, hey, this is who I name to be able to manage my assets in Miami, because I have to go back to my home country of Ecuador or Honduras, or if you end up in Spain, wherever. Without that, doesn't matter if it's your spouse or your child, adult child, they will not be able to make those decisions. Once you are 18, you need a legal document naming the person to be able to make those decisions on your behalf. So that is the benefit of having a power of attorney. It's easy and it's economical. It does not involve the court. You are setting it up ahead of time with an attorney saying, this is what I'm doing, this is who I'm naming, and that document is valid until either you pass away or you cancel the document. You say, okay, I don't need to give them a power of attorney anymore. I'm back in the country, or for whatever the situation is, you can cancel that power of attorney. Okay, where if you have a guardianship because you didn't plan ahead of time, that guardianship case, now you have a judge involved who has to oversee every decision that's being made. It is valid and open until the day you die. And as I tell my clients, the more you involve attorneys, the more you involve the court and judges, the costlier the whole process is going to be. That's just the reality. So this is the benefit of having and planning ahead of time. And it lets you choose, not the court, of who is going to be making those decisions on your behalf. So that is our power of attorney. Okay. Then Linda, I'll happily address all those questions. Yes, keep putting them in the chat and we'll go through them. Designation of healthcare surrogate. So this is similar to a power of attorney, but it's for health decisions. Okay. So your healthcare surrogate is a person that you authorize and to make medical decisions when you are unable to make your own decisions. Again, this could be a situation where you don't have the mental capacity because now you have dementia, Alzheimer's, or it can even be as simple as you are under anesthesia. You went in for a procedure. Let's say you went in for a colonoscopy or something, and you are under anesthesia, and heaven forbid there was some sort of a complication or something happened. There is a huge misconception, a huge myth that says, oh, well, but my husband, my wife, they can make the decision for me. The hospital will be like, oh, are you the wife? Unless you have a signed healthcare surrogate, they cannot legally make those decisions. I know that when you go to the hospital, oftentimes they'll have you sign like a little paper. That is only valid for that one instance at that one location. All the documents I am referring to and discussing here, this is part of a broader, more comprehensive estate plan. This is valid in the US, in the state of Florida, any hospital at any time in any place. Those situations where you go to a Leon Medical Clinic or you go to Baptist and you just sign right there, oh, who's your next or who's the person, that is like a very temporary, just at that moment type of situation. Healthcare surrogate is a legal document where it's valid until the day you die. You change it or you revoke it, saying if I can't make these decisions, these are the individuals, or this is the individual that I want to be able to make those decisions for me. And again, these documents, you can change them. Let's say you name, a spouse or someone, and then heaven forbid that person were to pass away. Well, obviously you need to remove them and add someone else. Or let's say you get divorced and you had your spouse. Well, now you don't want your ex-spouse making these decisions on your behalf, right? You're like, no, especially not when it comes to health decisions. I'll be like, pull the plug, let them go. So these documents can always be changed as your life circumstances change, but it's important to have them. So who can act as a healthcare surrogate, just like who can act on a power of attorney? It's any competent adult who is at least 18 years old. That's the only requirement. They don't have to be a blood relative. They don't have to be a child. They don't have to be a spouse. You can name a friend. You can name anyone as long as they are 18 years old and they themselves are competent to be able to make decisions on your behalf. Obviously, this is a big responsibility you're giving someone. So you really need to make that decision and think about, if you're not able to act, who would you want to act on your behalf? Make those decisions. Whose maybe beliefs and values align with yours? This is, something that you really need to think about. I've had situations where clients where maybe one of their children was involved in the medical field. They were a nurse practitioner or a doctor or anything. So they're like, well, look, this child, I want them to make medical decisions. And then with the regular durable power of attorney, which is more for financials, properties, things like that, maybe they want to name another child as the primary one there. It doesn't have to be the same exact people in the both documents in the same order. You can also name more than one at a time to act as co. My suggestion or advice for that is make sure those people are on the same page, because when you have two people that maybe don't have the same opinion or thoughts or don't get along, then the decisions are going to be hard to be made. So really think about it when you name co. I always advise my clients, it's always best if you have a primary person and then give me an alternate. So if that primary person is not available, let's say they're out of the country on vacation and something happens, then the alternate can come in and step in and make those decisions. Okay. And again, you can always change these and the people that you name as you need to. The next document we're going to talk about is a living will. This is very different than your last will and testament. They're two totally different documents, serve two totally different purposes and functions. So a living will is a document that's used while you're alive, just like the healthcare surrogate and the power of attorney, in which you are making the decision and you're letting your wishes be known as to your preference of medical treatments and what you would want and not want to be done to keep you alive in certain situations. So this addresses more end of life care and decisions. You're taking that burden off of your family, your loved ones of, well, would mom or would dad want to be connected? In a situation where if they're brain dead and there's, no possibility of them recovering. And the document has very specific language. This isn't just like, oh, well, mom's not doing well, let's pull the plug and move on. It's not like that. It has to be two doctors have to determine the type of condition and the probability of you recovering from that condition being non-existent and basically being in a persistent vegetative state. And then once it gets to that point that the doctors are like, we've reached this point, then the document states, well, what are your wishes at that point? Do you still wish to be maintained alive? Or do you not wish to be maintained alive and allowed to die naturally? Obviously with medication to not suffer in pain, but to basically let our higher power do what they're going to do and life take its course. So that's you letting know, hey, if it ever gets to this, I don't want to be in a bed as a vegetable, pull the plug, let me go, versus your family wondering what'll happen. And I have had situations where when this document does not exist and it has not been signed by a client and there is fighting amongst the family, amongst the siblings and a spouse, where then the hospital goes, we need a court order then. We need a judge to tell us who has the right to make this decision because you did not leave something in writing. So again, this is the importance of having all of these documents done to avoid those types of situations, which, trust me, I have seen happen. The advantages of the living will is that it specifies desired and unwanted treatments for later years, end of life, avoids family disputes, and eases their burden because you are making the decision. You are saying, when I get to this point, this is what I want. Nobody has to fight with that guilt of what do we do? You're telling them, this is what I want you to do. So it lessens that decision-making stress for caretakers because they already know and they already kind of have their instructions of what it is that your wishes are, and they're going to have to honor them and respect them. So you're taking that burden off of them. So those three documents we just covered, your durable power of attorney, your healthcare surrogate, and your living will, those are all while you are alive. Once the person passes away, those documents are done. They have no more validity. And then now we talk about, well, how are we going to distribute your estate? Who's going to receive what? Who's going to fight for the lladros? Or who's going to fight for the chain or the watch or the painting or this that they always wanted? If you don't have anything in writing, that's what it's going to happen. It's going to be a fight, and they're going to fight it out in court. So A last will and testament. This is one of the tools that we use in estate planning. It's good. It's not the best, but it's better than nothing. And it's important to at least have something written down, have something saying who you want to receive your assets. So a last will and testament, also known as a will, is a legally prepared and bound document that states your intentions for the distribution of your assets and your wealth the day that you pass away. So as I mentioned, the advantages of having a last will and testament is you control what happens with your property. This often comes into play and is very, very important when you have a situation of blended families. So let's just say that you have a house that you live in and you have adult children from a first marriage that they're established professionals, and then you remarried and now you have a second wife, and maybe you had a child with that wife and they're a lot younger. Well, maybe your desires are, well, my children, my older children, they're well established. I'm going to leave them some money, but they've made their life. Something happens to me, I need to care for my young child that is still, maybe 12, 15, whatever, under 18, and my wife. And this is the home they live in. So I wanted to go to her and my child until, they no longer live there, they move or whatnot. If you don't have that written down expressly in a will or a trust, the day you pass away, that property will get distributed according to what the court in Florida law says, not you. And Florida law is not going to say that that child and that wife received the house and not your adult children. And that's when family issues begin and fighting in court, dragging out probates for years and costing tens of thousands of dollars happens with someone's estate. And I doubt that that is what any of us intend or want for our family when we are not here. So the advantages is that you control what happens with your property. You save your heirs significant expenses and hassles of having to go through probate and avoid them having to fight and feud over that in court because there was nothing in writing saying who was to receive what. And you avoid that certain individuals receive maybe more or less than you would have preferred for them to have received. It's not a bad thing to say, well, I'm going to leave a certain amount to one child and a certain amount to another child. Once you are 18 years old, no parent has to leave a child any type of inheritance. None. They can completely leave. I apologize, my eye. They can completely leave their assets to a charity or whoever they want. So that gives you the control. Now, a little better than a will, or a lot better than a will, is a revocable living trust. So I'm sure all of you have possibly heard of, a trust and what is a trust, and you kind of maybe have an idea, but you don't, or you have that conception of a trust is for rich people, which is not necessarily true. So a trust, very similar to a will, is a written document that allows you to transfer ownership of most of your assets from yourself to that trust, and that trust will determine and lay out how you want the assets handled after you die. Well, Alina, that sounds like a will. Doesn't a will do the same thing? Yes and no, because a trust avoids probate, which a will does not. That is a huge difference between the two and an advantage of having a trust set up. There are also other advantages. So if your estate is a taxable estate, meaning it has a certain dollar amount where your heirs would have to pay estate taxes on, there are ways with different trusts that we can put assets in to avoid or minimize the amount of taxes. You can't do that with a will. Also, a trust is private. When you pass away, a will gets filed with the court and anybody can pull it up and see what the will said. A trust does not. A trust is private and nobody can see what the trust says as far as how assets are to be distributed. Also, an advantage with a trust over the will is that while you are alive, let's say you, for whatever reason, didn't do a power of attorney, but you do have a trust and your home is in that trust, right? We transferred it into the trust and you start to develop Alzheimer's dementia. the person that you named as your successor trustee, so the person to manage those assets when you are no longer here or don't have the capacity to, they can step in and manage the assets that are inside the trust. So that house, if it needs to be sold or anything needs to be done, they would be able to do that even if you're alive, but if you don't have the capacity to. And obviously that would have to be determined, by getting a letter from your doctor saying, look, they don't have the capacity. They can't just come in and say, oh, mom's crazy. She keeps forgetting things. So I'm going to take care of, manage all her stuff. It's not that easy. Okay. Because we all forget stuff. I know I forget stuff, and I'm not anywhere near having dementia, Alzheimer's. So it has to be proven, but that's another advantage. A will does not afford that. Okay. Also offers protection against court-appointed guardianship should you become disabled. That's exactly the situation that I just gave you there. With a successor trustee being able to step in and manage those assets. So there's a lot of advantages. Other advantages with a trust is, let's say you want to leave assets to a minor child or a grandchild. You're like, you know what? My kids have enough. I want to leave this for my grandchildren. You can't just leave a house or money to a 6, 7, 8-year-old grandchild. In a trust, you can, because you have a trustee who's going to manage it. And you can put certain conditions. You can say, okay, I want my grandchild to receive $100,000. Great, wonderful. But they don't get it until they're 25 years old, because I don't think at 18 they're going to be mature enough to know what to do with $100,000. So in that case, the person you name as the trustee would be able to manage that money. They could invest it, put it in a money market, a CD, a high yield savings, so it grows for the benefit of that child until they hit that age 25. Now, if they're not 25 yet, but let's say they come up to the trustee and say, hey, trustee, I need some money that my grandfather left me in my trust. And because I want to go to college and I need to pay for my semester at college, or I want to do a semester abroad this summer with the college, I need $10,000. The trustee goes, great, wonderful. Give me the information about the program or your courses. Who do I make this money payable to so I can take care of paying that? They'll be able to pay to the school, university, or whatever, straight from the trust on behalf of that grandchild what needs to get paid. So it's not that they don't have access to that money and they won't be able to use it. It's being managed by the person that you name, someone that you trust that's going to be responsible for managing that for your grandchild and protect it so they don't waste it, go to Vegas, party by themselves, some, 20 cars and spend all their inheritance. And now look, there's nothing left. That wasn't your wish. That wasn't your plan. That's what a trust allows you to do. Okay. So the difference between a revocable living trust and a last will and testament is that the trust lets you distribute property privately after death and avoiding probate court, while the will becomes part of the public records, does not avoid probate, and you can't manage certain rights or responsibilities or debts. A will just distributes it straight out to the beneficiaries. So a will is good. It's better than not having anything, but it's not the best. And that's a huge misconception people have. A lot of times they think, oh, I have a will, I'm good. You're not. It's not going to avoid probate. And it's possibly not going to set up the distribution of your assets how you really want them to be. So keep that in mind. So why a revocable living trust? Well, a revocable trust can be changed at any time by the grantor during your lifetime, as long as you're competent. So again, all of these things you can change while you're alive. They're your documents. I like to say they're like living documents. So if, let's say, I have a client that in his trust, he put a certain age restriction for his son to inherit. Now, my client's still alive, but he's getting older. And he came back to me a few years later and he's like, you know what, Alina, I need to change that age because I feel that my son is still, he's still not responsible enough. And I think I need to increase that age a little bit more because if I were to pass away right now, I don't think he'd know how to manage this amount of money and he would just blow his inheritance. And that's not what I want. So we change it. We increase the age. You can always make amendments to these documents while you're alive and you're competent. Okay. So how does a revocable trust avoid probate, which is one of the big things? That's the purpose of estate planning, is to keep you out of probate court, plan everything so that you don't, or your family doesn't have to go through all of that. So after you pass away, your named trustee, the person that you're entrusting to manage all of this on your behalf, they now have to say, okay, these are the assets that belong to the trust. We have a house, we have a bank account, we have this, we have that, gathers all the assets, and it says, okay, now it's time to distribute it. We're going to sell the house. We sell the house, the money becomes liquid. That money then gets divided according to what the trust says. Or maybe the beneficiaries say, no, we don't want to sell the house. We want to keep it as an investment property. Okay. The trustee would then sign a deed, deeding that property over to those beneficiaries. And now that's their responsibility. They've received their inheritance. So probate is avoided because there's no probate property. Everything belongs to the trust. Okay. That is how it avoids probate. You have to fund that trust and transfer those assets into the trust. So here's a little chart to kind of compare the similarities between a will and a trust and the major differences between wills and trusts. So the similarity is basically giving you the authority and the power to ensure that property gets distributed how you want it. You write it down in the document, this is how I want. So that's where both documents serve that same function. Where they're very different is a will dictates to what happens to your property when you die, and the assets belong to you, but it still has to go through probate, where a trust distributes your estate directly to those beneficiaries and can even be done. You make those decisions while you're alive. The assets belong to the trust. While you're alive, you're the owner of the trust, and then when you die, your beneficiaries are. Okay, so the purpose of a will versus a trust, the elements. So trust elements, the purpose is incapacity planning. If heaven forbid, while you're alive, you don't have the capacity to make decisions, that's where your trustee steps in and can make those decisions for you. So revocable trust allows you to maintain ownership and control while you're alive. Irrevocable gives that power straight to your trustee. So a trustee, that's the person you're naming to be able to make those decisions when you cannot. Who are the beneficiaries? Those are the people that are going to receive that. And that is your decision on who receives what. Assets, home, bank account. I wouldn't put cars in the names of trusts. Typically the way cars are held or boats or anything like that is once you pass away, if the car is sold, the money that you receive goes to the trust. But while you're alive, the car, the title to the car, the title to the boat, all that remains in your name. And with a revocable trust during your life, it's revocable. You can amend it. You can do it once you pass away, that trust becomes irrevocable. And the trustee is just there to make those distributions and the decisions on what's to happen with the assets based on what you left in writing. Okay. So like I mentioned, with trust, there are many different types of trusts. We can have a pet trust. Yes, if you have pets and you want to leave something and leave some money for the care of those pets, we can create a pet trust. There's gun trusts. There's all types of trust, charitable trust, if you want to leave money to a charity or anything of the like. But the most simplest, basic ones that we use every day are revocable and irrevocable. And here are the two differences. So with a revocable trust, you maintain control. It's flexible. You can change the terms of the trust during your lifetime, so long as you have the mental capacity, and you maintain control. Okay, you retain control over your assets, over the trust. It's still taxed. The estate is still taxed on the assets above the exemption amount at the time that you pass away. That's why it's important that if we have a taxable estate, we have other types of trusts set up to avoid estate taxes. So, and a taxable estate, just to give you a little bit of reference, is any estate that has currently, and this might change in 2026, currently any estate that exceeds $13.9 million in value. So these are big estates. That's why then you say, well, you know what? To avoid taxes, I'm going to create a charitable trust and I'm going to leave $500,000 in a charity to the American Cancer Society. And then I'm going to set up this other trust and I'm going to leave X. And that's how you break it off and to help avoid this taxes. And it also gives protection. During your lifetime, it does not give protection. Sorry, I stand corrected. From creditors. in a revocable. The reason why is because you maintain control of those assets. So that's another big misconception that people have, that, oh, it's in a trust, it's protected. Not necessarily. It depends on the type of trust that you have. That's why it is extremely important that you consult and go to an attorney like myself that specializes in this type of practice area. Because there are very, very important nuances that could affect your estate planning if it's not done correctly. So the advantages are the difference of the irrevocable trust, and we do use those in very select situations. I would say those are more used in a situation where we're planning for the future, for a parent that might, need aid, that might need to apply for Medicaid, things like that, or in a situation where maybe the beneficiary is a special needs person, so you don't want them to lose the benefits that they have. Those types of trusts are irrevocable trust. So the terms of the trust are locked in when the trust is created. It cannot be changed unless it's in a situation that you would probably have to go to court and get approval to change it. Typically, irrevocable trusts, you cannot amend or change them. You give up control of your assets. That's also why it kind of gives you the protection from creditors, because you no longer own those assets. The trustee is the one who manages it and owns it through the trust. But that's a benefit for a situation where you're setting something up or leaving an inheritance for someone with special needs or that receives benefits. Those are very, very, very important to use in those types of situations. And there are no taxes on the assets since the assets are outside of your control, because it's an irrevocable trust. You lose control of those assets. So irrevocable trusts are very useful, but you have to know when to use them and to use them correctly, because you lose a lot of control over the assets that are placed in an irrevocable trust. So let's go now to some of our myths and facts. And actually, you know what? Before we do that, I'm going to address Linda's question. It's that Linda wrote, what if you don't have adult children, siblings, or family that you can assign as a POA? Anyone that is over the 18 years of age, you can name as your agent. I have been named agents on behalf of some of my clients because they don't have anyone here. You can name someone that is not in this country, but I wouldn't suggest it, especially not on the healthcare, because if an emergency presents itself and they're not here, it kind of defeats the purpose of having that document. Can you hire the attorney as an agent? Yes, I have been named, not often. I try not to, because again, you're hiring an attorney. You're that person who's acting on your behalf would be entitled to receive compensation, because it's a big responsibility of managing your assets and so forth. But the short answer of it is yes, absolutely, you can. I always advise my clients, try to find someone, if you don't absolutely have anybody, by all means, yes, an attorney can act as your agent on your behalf. But it doesn't have to be necessarily a blood relative. It should be someone that you trust, someone that you know that's going to be making the best decisions, maybe even in accordance with your beliefs and what, how you would handle things. And someone that, is not going to be mismanaging or taking advantage of your situation, because we do come across that a lot of times, unfortunately. Does the agent need to live in the same state? No, they do not. They can live in another state. When it comes to the health decisions, like I just mentioned, I always advise and suggest that it be someone local. But for the durable power of attorney, it could be someone that lives in another state, in another city. Oftentimes I'll have clients where maybe they have their children that live in Orlando, Tampa. They don't live here in Miami. They're within Florida, but they're not here. That's fine. Or maybe they live in California or somewhere else. That's fine. They can still act as your agent. Just the logistical distance makes it a little bit more difficult at times, but they absolutely can. They do not have to be in the same state. But I would advise to try to find someone that is local if possible. But I get it if it's not. So, it's better to have at least someone you trust to make those decisions, even if they're not local. All right. So those are the questions we have. Let's go on to myths versus facts. Myth: I don't need an estate plan if I am young and healthy. Wrong. An estate plan is crucial at any age to prepare for any unforeseen circumstances and avoid complications. If I had a crystal ball and I knew the day I was going to die or what was going to happen in 5 years from now, I would be a bazillionaire because I could make strategic moves and plan knowing what was coming down the road. But unfortunately, those don't exist. But you know what does exist? Life. And life happens. And heaven forbid, if you find yourself in a situation where you have a car accident and now you're in the hospital and someone needs to make a decision on your behalf, you don't have your documents in place, doesn't matter if you're 20 or you're 90, they cannot make legal decisions for you. A big one that I've done, and it hits very close to home, and I did a webinar in August about this, is when you have a child that turns 18 years of age, they are considered a legal adult. And you as a parent lose all rights to be able to make a decision on their behalf. My son turned 18 in June, and the day that he turned 18 years old, we had all of our Walgreens prescriptions on a family account in the app. The day of his birthday, I received a notification from Walgreens removing him from our family account because now he is an adult, and that I would have to request from him to approve to be added back because it's now his decision. Yes, that shocking. And most parents do not realize that. And most parents at the webinar gave was focused to that, to parents who had children leaving out of state or out of town for college. What if an emergency presents itself? And I actually had a story, an article that had happened to a University of Miami student. She was coming back for her sophomore year. This was last year. Originally, she's from Rhode Island. She was coming back to start her sophomore year. She had gone out with some friends before school started, like the night or two before, to kind of, celebrate. And they went out in an Uber. There was some people that they met at a party. Somebody slipped her something in the drink. She became disoriented, didn't know where she was. And the Uber driver left her on the side of the road, not at the destination they had put. She wandered into traffic and she was hit by a car. She ended up in the hospital. The hospital called up her mother, who was a nurse in Rhode Island. So she's in the medical field. She understands. And they called and said, "Are you the mother of so-and-so?" She said, "Yes, I am." She says, "Do you have a medical power of attorney for your daughter?" And she said, "No, I don't." And they said, "Unfortunately, we cannot give you any details, but you need to get down to Miami. She has been in an accident. She is in the hospital." That is all they would tell her. When she came down to Miami, she could not make any decisions because there was no legal document. Basically at that point, the hospital takes precedence of making whatever decisions are necessary based on the physicians. They had her on life support. She did not want her to be on life support. She was brain dead. Unless she went to the court and obtained a court order appointing the mother as the one to make the decisions, the hospital continued, and within 10 days, she passed away. But throughout those 10 days, the mother was there suffering, watching her child, a vegetable in bed, not being able to make any decisions or find out any information whatsoever because she did not have a medical power of attorney, and her daughter was 19 years old. And in the eyes of the law, she is an adult. So that is a wake-up call, and that applies to everyone. Just because I've been married to my spouse for 23 years does not give him the right to make any decisions on my behalf unless I have a legal document. Doesn't matter. And as far as any of you here from Florida, if you're familiar, back in the day, the case of Terri Schiavo was a very big case here in Florida. She had a heart attack at 26 years old. She did not die from the heart attack, but as a result of her brain having lost oxygen for so long, she was brain dead. She was a vegetable. And there ensued a 15-year litigation between her husband and her parents as to who had the rights to make the call of whether to disconnect her or not from life support. Because, again, she was young. She didn't think she needed any of these documents. And she had no living will, no health care surrogate in place. Her case went up to the Supreme Court of the state of Florida, where finally they decided that the husband had the decision making and Once they disconnected her, she immediately passed away because she could not live on her own. But for 15 years, her husband suffered, her parents suffered, and they spent hundreds of thousands of dollars in legal battle over who had the right, which could have been avoided with one simple document. Okay. Another myth: if something happens to me, my parent or spouse can automatically make medical decisions. No, we just talked about that. No, the fact is, if you are over 18, no one can legally access your medical information or make medical decisions unless you name them in writing by way of a healthcare surrogate, healthcare proxy, or a living will. HIPAA laws prohibits the release of any information. Just like I gave the example of my son. If he goes to if he goes to his doctor now and he doesn't want me in the room, he can say, Mom, I don't want you in the room. Go sit outside. And the doctor has to respect that and doesn't have to give me any information. If I call and say, hey, I need to find out where the results are at, if I'm not my son and I don't have a document, they're not supposed to give me that information because they will violate HIPAA laws, even though I am his mother and in my eyes, he is a child. So, myth. Any property I owned before getting married will automatically go to my kids if I die. This is a huge myth. And we see this happen so much. And unfortunately, the result ends up being families being torn apart in court because the person thought, well, I bought this property 10 years, 5 years before I got married. I'm married, but I already had my kids. My kids are adults. Well, that's mine. It's my property. It's in my name. It's going to go to my kids. Absolutely not. In Florida, your spouse has automatic inheritance rights, even over property that you owned before marriage, unless you have a proper estate plan or you did a prenuptial agreement. Without one, your kids will not inherit 100% of that property. Next myth. If I die without a will, my family will just divide everything fairly. Not true. Well, not always true. Some families might if they truly respect your wishes and are in agreement, but why leave it to chance? Because I've seen it start that way and not finish that way. In Florida, not your family, Florida law decides who gets what. And the distribution may be very different from what you would have chosen. Earlier, I talked about a situation where, let's say you had older children from a first marriage, and then now you had a younger child. You're like, well, these older children already have their life established and done. They don't need my help, but my younger child does. If you don't leave it in writing and you don't have a proper estate plan, that will not happen. According to Florida law, it'll distribute it according to what it says, and it will not take into account, well, this child's a minor. That does not matter. Myth. Probate is quick and simple in Florida. No, nothing involving the courts, a judge, and attorneys is quick and simple. It's not. And I am an attorney. So, fact, probate can take 6 to 18 months or longer and cost thousands of dollars. Most families want to avoid it, but you have to plan ahead to do so. I currently have a probate case that we have been litigating for almost 3 years. And this is not a huge estate. And unfortunately, each side is paying thousands and thousands of dollars fighting over, in all purposes, trivial things. So to finish this off, and then I'll go back and answer, I see there's a couple more questions there. This is very kind of similar to the Terri Schiavo case that I mentioned. This one was a case, Nancy Cruzan, 1983. She was in a serious car accident. She was 30 years old. That's not old. She probably thought, I had my whole life ahead of me. Why do I got to do estate planning? I'm only 30. She was in a serious car accident that left her without oxygen to her brain, resulting in a permanent vegetative state. She was kept alive in a Missouri State Hospital through a feeding tube. She couldn't communicate, couldn't make any decisions, nothing. In life, she had told friends and family that she would not want to live this way if this ever happened to her. Unfortunately, you can scream it from a mountaintop, but if it's not in writing, it doesn't matter. So her parents had asked to remove the feeding tube, but because there were no advance directives, no living will, healthcare surrogate, or nothing, the hospital and the state of Missouri were the ones who were making the decisions and required court approval. And there was a legal battle, long legal battle, all the way up to the United States Supreme Court over who would make decisions on Nancy's behalf. It was only after additional testimony about her wishes did then the court decide to allow the removal of the feeding tube, and eventually she passed away 11 days later. This is very similar to the Terri Schiavo case, and like this, trust me, there are plenty of cases, and this all can be avoided by just taking care of doing your estate plan, having those conversations. I know they're uncomfortable. No one wants to talk about dying. No one wants to talk about situations like this, but it's necessary, especially if you want your wishes respected and you want to let them be known and relieve that burden from your family. Okay, so I'm going to go back to the questions. Okay, we addressed that one. So Linda, again, what if you create all these documents while living in New Jersey, but then retire to live in Florida? Do you have to create a new set of documents? It depends. It all depends, because within the United States, each state, like for example, I'm a licensed attorney in the state of Florida. So I can only prepare documents for people here in the state of Florida that conform to Florida law. Certain states have little nuances and differences. We would have to review those documents and make sure that those New Jersey documents meet our Florida requirements. And if they do, you can use them. Doesn't matter that you created them in New Jersey, but they have to meet the Florida requirements. Same thing with the trust and everything. If they don't, we can obviously then amend them, do new documents here. If you already have a trust that's created, we can do what's called a restatement of that trust to basically adopt Florida law. But the short answer is it depends. An estate planning attorney here in Florida, where you're going to be residing, really should look at that to make a determination of whether or not we can use it. For the most part, I have yet to really come across documents like, oh no, forget it, we cannot use it. For the most part, we can, with making certain, changes. Like Florida, we're very big here. We have a very big protection when it comes to our homestead. So, or other states don't. So little things like that, but it's state specific, but we can review it and possibly need it and use it. How about if kids of special needs that are adults? Well, that's another wonderful topic. I'll probably do a seminar on that another day. But if you did not, so until they're the age of 18, any child, whether special needs or not, until they reach the age of 18, you are their legal guardian and you can make the decisions on their behalf. Once they hit 18, even a special needs child, you should have a guardianship done for them. Where that guardianship, because depending on the extent of their special needs, if a doctor determines that, yes, they can understand and sign documents, then they could sign it. If not, then you would open up a guardianship case with the court, where then the court would legally appoint you as their guardian for the remainder of their life. And then you can make all those decisions on their behalf. But that is very, very important to do. And again, a lot of times special needs parents don't understand that or don't know that. If you have someone that is, severely autistic, nonverbal, anything to that, Down syndrome, anything, please, it's very important that before they turn 18, you start getting everything in order and everything, ready to then continue. There's no gap in being able to make decisions and be their guardian. And we do handle a lot of guardianship cases for children and for adults. Adults that did not do their power of attorneys, and now we need to open up a guardianship so that their spouse or their child can be named as their legal guardian and make those decisions. So if a prenuptial is signed and properties are not updated in the prenuptial, some have sold and others have been purchased after the prenuptial. Okay, I don't understand the question form. Okay, but I'm assuming you mean, so with the prenup, at the time that you sign the prenup, obviously it's before you get married. You list, each respective person lists whatever assets that they have. And they say, this is mine, this is yours. Anything from this point back that we've acquired is our respective properties. Anything going forward, typically acquired through the marriage, is considered marital assets. Now, if you sold one of your prior properties, that's fine, you sold it. There's nothing for you to do. If you acquired a property after the marriage, then the prenup would say, well, that's a marital asset. So then there it goes under marital assets and spouses have certain rights in the state of Florida as far as the way that you leave the distribution. So again, in that situation, it's important if you have anything that you acquired prior to your marriage, that you have that prenup to protect and say, this is not yours if I die. Anything after the marriage typically is part of your marital assets and your spouse would have certain rights. It's very important to have that clearly defined and that the prenup to be done correctly so that it can be not only valid in a divorce situation, but also be valid in an inheritance situation. Okay. I hope that answered your question. So this concludes our webinar. I hope, oh wait, we have one more question from Linda. What if a will assigns all assets to a niece in New Jersey? Are there inheritance taxes? And if so, how can the owner of will protect or prevent these taxes from absorbing all the assets? Okay, so if your niece is in New Jersey, well, yes, they can inherit under even though they're in New Jersey, but if the assets is located here in Florida, they're going to deal with the taxes and the inheritance laws based on their state. Florida does not have an inheritance tax. It's at a federal level. So that's anywhere in the US. Whether New Jersey has some additional taxes on inheritance, that they would need to speak to a CPA or an accountant in that state. But if they're inheriting a property here in Florida, we have no inheritance tax unless that property is more than $13.9 million in value. In that case, you did your proper estate planning to help avoid or minimize the taxes. So if there is no estate planning done, you're not going to avoid taxes. You need to do proper estate planning to avoid any type of inheritance taxes. But in Florida, there's no inheritance tax. That's why we have all the snowbirds that love to come here, retire here, because there's no inheritance tax in the state of Florida. It's at that federal level, which currently is the $13.9 million. Anything above that, so up to that amount, tax-free. So how long does it take to do these paperwork? It all depends. I meet with a client from the time that we meet with a client here in our office, our legal team, to do the initial consultation. Sometimes we can easily turn this around within 30 days. Sometimes it takes a little longer. It all depends on if you know who you're going to name as your trustee, if you know how you want to distribute your assets. A lot of times people come for the first time and they haven't even thought of this. And I tell them, people sometimes have the misconception. They come in, they're like, well, my estate is simple. It's simple. I don't have a lot. I have a house. I have this. I don't have a lot. What makes estate planning complicated is not always just your assets. Yes, that is one part of it. Oftentimes what makes estate planning more complicated is, do you have minor children? Do you have special needs children? Do you know who you're going to name as the trustee? Do you know who you're going to name as the guardian for your minor children if both of you pass away? Those questions are the ones where people are like, I haven't thought of that. I don't know. That's what takes the longest. So as soon as we have all of that information from you, we usually can turn around an estate plan 30, 60 days tops, sometimes a little faster. If you come in and you're prepared and you know everything and you get us everything that we need, in 3 weeks, so we can have it done. It all depends on what we're preparing, the information that we have, whether or not you've thought it through, made decisions. I've had clients that will sit here and change their mind, and it takes us 6 months to finalize their estate planning. So it all depends on you in a sense. So typical cost, again, it depends. It really does. No estate plan is the same for every individual. My estate plan is going to be different than your estate plan because I have a minor child. I might want to leave something to, a person that might have, special needs. I've had clients that leave assets to an adult, but maybe they have a, alcohol addiction or something like that. So their concern is, well, we need to set up a trust. We need to do this. It really does depend. To give you a broad range, it could be somewhere anywhere from maybe $1,000 to $10,000. I know that doesn't help, but it really does depend. That's why it's important to sit down, do the consultation, and not just look at the assets. That's a big misconception. It's not just the assets. It's the totality. What are your wishes? Who are we leaving things for? Who do we have to take into consideration? Do we have to put any special clauses in place? What are we doing? It's not just, oh, I have a house and I have money, so my stuff is simple. No, it's not always that easy. If you purchase properties after prenuptial, solely purchased by one spouse, named under a trust of one spouse, if inheriting goes to a spouse's child, it all depends what the prenup says. You got to see what the prenup says. Because even if you purchased it in your name only after you're married, were marital assets used for it? Meaning, did you take money out of a joint account with your spouse to buy that house? Then now it's a marital asset because a joint account fund contributed. You've got to read, we would have to read and look at what the prenup says. We can't just make, these are all legally binding documents. Think of them as contracts. And we have to see what it says to then be able to make a legal decision on who has legal rights or not. Do you have 30-minute free consultation to speak to you, or is there a fee to see you? We do a 1-hour sit-down comprehensive consultation, and we do charge $350 for that 1 hour, because that is 1 hour dedicated time to you by our legal team. It could be with me, it could be with my associates, it could be with my director of services. It all depends on the availability. If you hire us, we credit you back those $350. So the consultation does turn out to be free. But we do have to charge because we're taking out 1 hour of our day of the calendar to sit down and do a one-on-one consult. That is your time dedicated to you to go through your plan, your needs, what concerns you have, and making sure that we're doing everything correctly and putting it together for you. And if you hire us, we gladly give you that credit back and credit it towards whatever the fee is. So in essence, the consultation does turn out to be free. If you have a trust, then you buy a house. Don't buy the house under the trust name or personal. Okay, so if you have a trust and you buy a piece of property and you buy it in your individual name, that property is not in the trust. So it's like having a safe. You can buy a safe and not put anything in it. The safe is empty. The purpose of the safe is to protect things. You have to fund your trust. So if you want that property, you don't have to have it pass through the trust. But if you want it to pass through the trust, then you have to purchase it in the name of the trust. Or let's say you bought it already, which is what we typically do for our clients that come to us to do their estate planning, and they have it in their individual name. We do the deed to transfer the property from their individual names to the name of the trust. And we take care of recording it with the county and making sure everything is done correctly. So I hope that answered your question. But if you already have an existing trust and you want that property to go through the trust, yes, you need to take title in the name of the trust, not in your individual name. If you do it in your individual name, you're going to have to transfer it later and pay additional costs to do that when it can be done at the same time of the closing. Okay. So thank you for your webinar. Reach out. Thank you so much, Reina. I hope all of you have enjoyed it. I hope you have found it informational. I hope you learned. We will be reaching out to you as well. If you would like to schedule a consultation, we'll be happy to sit down with you, go through everything. Or if you already did your estate planning at some point, you want to make changes to it, or you want to see if what you have is enough and it protects you, please, by all means, we'd be happy to do that as well. So follow us on all of our social medias, Nunez Law Florida on Instagram, YouTube, TikTok, Facebook. I put out a lot of videos, a lot of content, and we announce any webinars that we're having in the future. And enjoy your day. Have a wonderful and blessed day. And again, thank you, Alina. You're wonderful. Thank you for very specific info. I learned a lot, but I live in New Jersey. And you're very welcome, Linda. No worries. You have me here. If you ever come to Miami or to Florida, if you buy something here, give me a call. I'm happy to help. And yes, please take care of your estate planning. Don't leave that headache to your family. I do probate litigation, and I see what not having proper planning does to a family, and all of that can be easily avoided by just taking the time and making these decisions and having these, uncomfortable conversations. But once you have them, they're done, and it's peace of mind. All right. Have a wonderful rest of your day, guys, and follow us on social media, and hope to see you all at the next webinar or in person here in our office. Take care.